Hello, my name is Dr. Debaruti Haldar and I'm a professor for Department of Research, United World School of Law, Gandhinagar, Gujarat, and I'm also the Honorary Managing Director for Center for Cyber Victim Counseling. This module is titled as Digital Evidence. This module will help us to understand the concepts of digital evidence, how digital evidence can be collected, the admissibility of digital evidence in Indian courts. This module is divided into 4 parts: introduction, admissibility of digital evidence, how to get the digital evidence, summary and conclusion. The learning objectives of this module are to understand what is digital evidence, to know whether digital evidence is admissible in law in India, to understand how to get the digital evidence without breaking the chain of custody, to know the responsibilities of the police to protect the digital evidence, to understand how the victim of cybercrime may produce digital evidence. It has been seen that cybercrimes may either be committed with the aid of the computer or computer system or computer networks, or through the computer system or computer networks, etc. The classic examples of the earlier can be cyber-assisted murders, bank robberies or simple robberies, sextortions, shadowing and stalking, etc. For the later, classic example can be attacking the government websites and defacing them, unauthorized access to personal data or public data, misusing the same, revenge porn, phishing, job scam, cyber terrorism, cyber stalking, voyeurism, etc. In both the cases, various electronic devices or computers may be used. For example, desktop or laptop computers, smartphones, etc. With the advent of technology, several other devices like the Google Glass, etc. are also being used to penetrate privacy of individuals. Whenever any computer or computer device is used for committing any crime, it becomes essential to get the digital evidence for prosecution. Unlike real-life physical crimes, where evidences may be collected by way of fingerprints, bloodstains, or any other mechanism, in cases of cyber crimes, collection of evidences is not easy. It needs trained police officers to collect the digital evidences and also to analyze the same for getting the correct track. Often, it has been seen that digital evidences may lead to geolocation of the offender, time of committing the crime, and target victims, but it may not be able to get the actual persons, as the evidences may show only the person who owns the device and not the persons who may have used it for the purpose of committing the crime. In such cases, it becomes a Herculean task for establishing the identity of the perpetrator. Further, it may also be seen that the police may ask the victim, in case of the attack on individual, to collect the evidences. The victim may never know what evidences may be collected and how it can be collected. There have been several cases where the device, like the desktop or laptop computer or the smartphone, may have been seized by the police for some offenses, but no accused could have been arrested due to jurisdictional issues. Information Technology Act 2000 brought in several changes in related laws, including the Indian Evidence Act, which even though was drafted almost a century ago, was amended to suit the needs of digital crimes. Admissibility of digital evidence. Section 3 of the Indian Evidence Act explains the definition of evidence as all documents, including electronic records, produced for the inspection of the court. The term digital evidence is explained by Casey as digital evidence or electronic evidence is any probative information stored or transmitted in digital form that a party to a court case may use at trial. However, before accepting the digital evidences, courts must verify whether the same is relevant evidence or authentic evidence or hearsay evidence. As such, digital evidences may also include electronic records. The term electronic record has been explained by the Information Technology Act 2000, amended in 2008, as follows. Electronic record means data recorded or data generated, image or sound stored, received or sent in an electronic form, or microfilm or computer generated microfiche. The question is whether the electronic record is recognized as an evidence, and if so, then whether it can be an admissible evidence or not. The first question is answered by Section 4 of the Information Technology Act, which states as follows: where any law provides that information or any other matter shall be in writing or in the typewritten or printed form, then notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is rendered or made available in an electronic form and accessible so as to be usable for a subsequent reference. The admissibility of digital record or evidence is dealt with under Section 65B of the Indian Evidence Act, which states that notwithstanding anything contained in this Act, any information contained in an electronic record which is printed on a paper, stored, recorded or copied in an optical or magnetic media produced by a computer, hereinafter referred to as the computer output, shall be deemed to be also a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceedings without further proof or production of the original, as well as the evidence of any contents of the original or of any fact stated therein, or which direct evidence would be admissible. The conditions referred to in subsection 1 in respect of computer output shall be the following, that is, the computer output containing the information was produced by the computer during the period over which the computer was used regularly to store or process information for the purposes of any activities regularly carried on over that period by the person having lawful control over the use of the computer. During the said period, information of the kind contained in the electronic record or of the kind from which the information so contained is derived was regularly fed into the computer in the ordinary course of the said activities. Throughout the material part of the said period, the computer was operating properly, or if not, then in respect of any period in which it was not operating properly or was out of operation during that part of the period, was not such as to affect the electronic record or the accuracy of its contents, and the information contained in the electronic record reproduces or is derived from such information fed into the computer in the ordinary course of the said activities. Where over any period the functions of storing or processing information for the purposes of any activities of any regularly carried on over that period as mentioned in clause A of subsection 2 was regularly performed by computer, whether by a combination of computers operating over that period or by different computers operating in succession over that period, or by different combinations of computers operating in succession over that period, or in any other manner involving the successive operation over that period in whatever order of one or more computers and one or more combinations of computers, all the computers used for that purpose during that period shall be treated for the purpose of this section as constituting a single computer, and references in this section to a computer shall be construed accordingly. In any proceedings where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things, that is to say, identifying the electronic record, containing the statement and describing the manner in which it was produced, giving such particulars of any device involved in the production of that electronic record as may be appropriate for the purposes of showing that the electronic record was produced by a computer, dealing with any of the matters to which the conditions mentioned in subsection 2 relate, and purporting to be signed by a person occupying responsible official position in relation to the operation of the relevant device or the management of the relevant activities, whichever is appropriate, shall be evidence of any matter stated in the certificate, and for the purpose of this subsection it shall be sufficient for a matter to be stated to the best of the knowledge and belief of the person stating it. For the purposes of this section, information shall be taken to be supplied to a computer if it is supplied thereto in any appropriate form, and whether it is so supplied directly or with or without human intervention, by means of any appropriate equipments, whether in the course of activities carried on by any official, information is supplied with a view to its being stored or processed for the purposes of those activities by a computer operated otherwise than in the course of those activities. That information, if duly supplied to the computer, shall be taken to be supplied to it in the course of those activities. A computer output shall be taken to have been produced by a computer, whether it was produced by it directly or with or without human intervention, by means of any appropriate equipment. Explanation attached with the section further states that for the purposes of this section, any reference to information being derived from other information shall be a reference to its being derived there from by calculation, comparison, or any other process. As may be seen from various case laws, several electronic records, including computer printouts, emails, SMS, MMS, call data records, IP addresses, electronic bank statement, etc., were taken as admissible evidences. Also, recent understanding by the courts, including the Supreme Court, has extended the meaning of electronic records and digital evidence to include social media like Facebook and WhatsApp messages and posts. Even though both the social media sites have their own policy and guidelines providing details of the originator of the posts, the extraterritorial jurisdiction of the Information Technology Act may be used for compelling the websites to reveal the names of the originators to show who was handling that particular profile, from where the offensive posts or communication was posted. Now we will discuss as how to get the digital evidence. As has been discussed above, there are two ways to get the digital evidence: to seize the device as a whole and put it to forensic lab for extracting the digital evidence in case the investigating officer is not well versed with the computer and does not know how to handle the digital evidences, and to take record the call logs, emails with headers, links of the particular websites, pages, etc., where the offensive post has been seen. The second way may be adopted by the victim or the viewer himself or herself if he or she is aware how to record or store such links, documents. It needs to be remembered that the victim or her family members, in case the victim is not fully digitally literate, should take up the first responsibility to collect as much evidence as possible. The digital contents are erasable in nature, and it has been seen many times that the perpetrator, after creating the offensive contents to cause harm to the victim, may subsequently withdraw the same along with the digital identity that was created to or availed by the harasser to cause the victimization. It is for this very reason that the victim must save the harassing contents, but at the same time, it must also be ensured that in case the victim is unable to report crimes to the police or the courts, any other person who may be willing to help the victim must be properly authorized by the victim to lodge the report to the police. It may be understood that there are several legal provisions, including Protection of Children from Sexual Offences Act, that is POCSO, Juvenile Justice Care and Protection Act, Sexual Harassment of Women at Workplace Protection, Prevention and Redressal Act 2013, Indecent Representation of Women Prohibition Act, and the concerned rules, etc., which provide confidentiality to the victims, whereby the victim may anonymously lodge complaint or may take help of her family members or friends to lodge the complaint, and the names of the victims cannot be published by any reporting or investigating agency or body. But all these legal provisions, as well as Indian Evidence Act, also provides that the burden of proof of victimization lies on the complainant, that is the victim. As such, lodging reports regarding victimization which may involve harasser whom a third party complainant, who may be a cyber bystander, believes to be a harasser just because he or she may have reason to believe that the offensive content targeting a particular victim was generated by him, that is the harasser, may push the third party complainant to legal trouble. This is because the supposed harasser may also be the target of the real perpetrator. Further, the real perpetrator may create fake identities impersonating the supposed harasser, or may be in nexus with the victim for pulling the supposed harasser to trouble by creating offensive contents against the victim through the impersonating identity of the harasser. If the real perpetrator wishes to escape the legal liabilities, he may thus invite cyber bystanders to frame false evidence unknowingly. The other factor that the victim or the complainant needs to remember is not to publicize the victimization in other public forums if he or she determines to register a complaint with the police and the courts. This may not only escalate the problem more by attracting more anger from the actual harasser as well as trolls who may start trolling on this issue, it may also weaken the case for the victim or the complainant. The harasser may claim that the victim had unnecessarily brought in more pressure on him and provoked him or her to attack the victim in a more grievous manner. The harasser may also claim that he was exercising his right to speech, which the victim unnecessarily attacked. In sum, such activities may corrupt the actual evidences as the offensive content may be removed or modified or edited and then may get published in the completely different form. In such case, the victim herself or himself or her friends or the compassionate cyber bystanders may be held liable for destruction of the document or electronic records as has been provided in section 204 of the Indian Penal Code. Further, it is also very much necessary to note that circulation of offensive messages or videos for a wide publicity of the issue may attract section 67, that is punishment for publishing or transmitting material containing obscene acts etc. in electronic form, 67A, that is punishment for publishing or transmitting material containing sexually explicit acts etc. in electronic form, 67B, punishment for publishing or transmitting material depicting children in explicit acts etc. in electronic form of the Information Technology Act 2000 amended in 2008, and also section 354C, that is voyeurism, and of the IPC, and also sections 11(3) of Sexual Harassment and Punishment Act against the children, that is the POXO Act. Section 12 and 13 may also be pulled in, including section 14, which speaks about punishment for using children for pornographic purposes, etc. Such activities may also destroy chain of custody in case the victim has already given the harassing contents to the police and the police have started initial investigation. Further, such publicizing may also attract blame game from the police as well, especially when the police officer concerned is not well aware about the internet crimes issues. Once the victim has all the proofs ready, he or she may decide to register the complaint with the police with all the evidences he or she may have. Often there is confusion as where to lodge the complaint. Section 78 of the Information Technology Act 2000 amended in 2008 says, notwithstanding anything contained in the Code of Criminal Procedure 1973, a police officer not below the rank of inspector shall investigate any offence under this act. As such, if the offence is in the nature of any offence which are described in chapter 11 of the Information Technology Act, or any offence in the nature of cyber stalking or voyeurism or creation or distribution of rape videos, etc., the victim may contact the inspector in charge of the local police station first. Thus, in short, victims must not delete the message, content, mail, etc. Rather, they must save the copy of the same along with the link that may appear in the header bar. Victims must refrain from answering or sharing the offensive content. If the content looks like a malicious link or virus, the victims must not open the same, but they may take a screenshot of the link and store or save it for further investigation. For example, let us take the example of a mail received by an individual from an account which may be suspicious. The receiver may take a screenshot of the sender's link without opening the mail. Next, the receiver may find out the real address of the sender by simply putting the cursor on the sender's initiation, example IH. In this case, the information below surfaced when the cursor was placed on the initials. It needs to be noticed that the receiver need not press to open the link. It may automatically open the information once put on the initials, that is, some names. As may be seen, this is a spoofed mail sent by spammers to possibly spread virus in the computer or for phishing. Even though certain email service providers like the Gmail etc. have provided reporting mechanism for phishing, in case the victim had unfortunately clicked in the email and has become victimized, he or she may consider taking the following steps to save the evidences. The other important mechanism to record the evidence is to save the header of the mail, which may provide the path, the link and the original sender's email ID and IP address. For example, Support Google provides a guideline for getting the header for Gmail, which is as below. That is, they say, log in to Gmail, open the message you would like to view headers for, click the down arrow next to reply at the top of the message pane, select show original. The full headers will appear in a new window. In case of social media contents, the victim may follow quite the same mechanism to store the digital evidence of the offensive content. For example, if it is a Facebook content, the victim may not only save the screenshot of the offending content, he or she may also copy the link of the page where it was published. For the police, especially investigating officers, the way of collection of evidence may differ with the expertise of the same. Before conducting the search, the police investigator will need to decide whether to seize the data on site or seize hardware for examination at a computer forensic laboratory. While on-site data seizure has the advantage that one does not have to transport much hardware, one may need services of a computer forensic expert to download data for analysis and preserve the data for presenting it in the court. When in doubt, make use of a computer forensic specialist at the scene, if possible, to determine whether one needs to seize the data or seize the hardware. In case a specialist is not available, it is recommended that one seizes everything. But when the nature of the offense involves circulating images or audiovisual clippings, and if the victim or the complainant provides reliable information about the origin of such data, for example, in cases of interpersonal crimes like sexting and revenge porn, cyberstalking, creation of fake avatar, etc., the victim may be aware that the concerned data has been stored in the devices of the harasser, who may be ex-boyfriend or ex-husband or any other known person with whom the victim would have exchanged the information earlier. Or even when the crime consists of hacking and unauthorized access to data or creation, distribution of sexually explicit materials, the investigator must also seize the devices as well. For search and seizure of digital evidence, the police may take some precautionary issues that the investigator must remember. While planning for search, our intangible data can be stored in any jurisdiction in any networked computers, and the perpetrators can access these data with dial-in accesses from anywhere in the world. The quantity of information misused or amount of the damage to the data or even the viral nature of the content may be controlled by the speed of the network and the equipment that the criminal is using. It is always advisable to contact the computer forensic scientists of a forensic science laboratory and ask them to accompany the search team to the places where the investigator suspects that the computer or the computer networks or any other electronic memory devices are likely to be found. In case it is not possible, the investigator must remember to collect information including the type, make, model, operating system, network, architecture, type and location of the data storage, remote access possibilities, etc., which can be passed on to forensic experts. That would help in making necessary preparations to collect and preserve the evidence. When on some occasions it may not be possible to remove the computer or computer system physically and data may have to be copied at the scene of the crime or place of the search, the investigator or the expert must carry necessary media, software and other specialized items as well as special packing materials which can prevent loss of data, as data of magnetic media can be destroyed by dust, jerks and electrostatic environment. Suspect or an accused should not be allowed to touch any part of the computer or accessory attached to it, either by physical means or through wireless. Physical networks such as fiber optic, cables, telephones, or on Wi-Fi or Wi-Fi Max wireless networks, or even through a mobile phone having a wireless communication port, etc., must not be allowed to be touched or switched on by anyone on the site, including the accused, since the data may be corrupted or wiped out even by remote controlling by different devices. Investigator must take similar precaution for small devices or removable storage devices which have the capacity of storing huge amount of data. In case the data reside at a remote location, even in a different country or jurisdiction, the investigator needs to find out the storage location and take action accordingly. In such case, the investigator must consider to alert the Interpol and take necessary follow-up steps to issue letters rogatory under the provisions of section 166A of CRPC. When the investigator finds networked computers, he or she should not disconnect the computer if networks or mainframes are involved, since pulling a computer from a network may damage the network and cause harm to the company's operations. Thank you.